rise. The Court of Appeals Division 1 is now in session.
Good morning. Be seated. Now is the time set for oral argument in consolidated cause numbers SA150292, Simpson versus Miller, and SA150295, Martinez versus Steinley. For your information, these proceedings are being recorded. Excuse me. We had to do some running here to get over. So barring any unforeseen problems, you can critique yourself on YouTube or get the audio or whatever you want to do in a couple of weeks. Counsel, as I'm sure you are aware, each side will be entitled to 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know and we'll try to not eat up all your time. But ultimately, it is your responsibility, your obligation to save that time. We've reviewed the briefs. We have conferenced the case. We're well aware of the facts and issues attendant to this argument. And we say that to give you the opportunity, knowing how you pled this case, to decide how best to use your time. When you come to the podium, counsel, I would ask that you state your name and who you represent. And with that, counsel. Excuse me.
May it please the Court. Woody Thompson on behalf of Jason Simpson. With respect to division of time, I intend to speak for 10 minutes. Jay Cabu, counsel for Martinez, will present for the remainder of the time in rebuttal. As the United States Supreme Court has held, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. That's the Salerno decision. This right is a basic tenet of the due process in our country's criminal justice system. Here, Arizona's bond deprivation scheme under ARS 3691A3 violates this paramount liberty right. The scheme casts too wide a net. It constitutes an impermissible scattershot approach because it necessarily denies bail to individuals who may not pose any danger to the community or pose a public safety risk or flight risk.
Counsel, let me ask you a question on that. I think the law is pretty well established that for capital cases, this type of statute passes constitutional muster. So what is it about this provision, A3, sexual conduct with a minor, that differentiates it?
In the Lopez Valenzuela decision, they do briefly touch upon the point that Your Honor made. They do say it's an open question about death, and I certainly would point out that death is different.
Well, I don't think they said it was an open question about death. I think they said it was an open question about non-capital cases.
And they said that death was generally thought, correct. But I would point out that death is different, and there's an entire body of American jurisprudence on this point. The Supreme Court has held that the penalty of death is qualitatively different from a sentence of imprisonment, however long.
Counsel, let me kind of direct the question a little bit. I think the underlying rationale on the capital cases is there's a sort of a inherent dangerousness from someone who's charged with a capital offense and flight risk, that they would flee to avoid the death penalty. All right, fair enough. The charge here, or the two counts, deal with sexual conduct with a minor under the age of 15. Conviction on those two counts alone would be mandatory consecutive flat times stacked offenses. So we're looking at a minimum of what, 17, or presumptive of 17 on each of those counts. And then the nature of the conduct is someone who allegedly took two young girls and for money had them perform these acts. Doesn't that conduct pose a danger to children in the community, and isn't the risk of that type of incarceration an incentive for someone to flee if we're to go on those principles that guide the capital cases?
Well, I would
How is it different? That's what I want to know.
So I would say, first and foremost, that death is different. And what I was trying to get at...
Counsel, don't just say that.
Okay.
I mean, under the release statutes, why and how is it different? Because it's not, if we're going to talk about a 14th Amendment due process analysis or an 8th Amendment analysis, just saying death is different really isn't guiding my discretion.
Understand. So what I was trying to get at was that one is ending somebody's life, and the other one can be a long prison sentence, as Your Honor suggested. And so I would argue that they're qualitatively different, and I believe there's an entire body of jurisprudence. But what we need to look at is this a convincing proxy? Has the state put forth evidence that this type of charge is a convincing proxy to manage this flight risk and safety risk to the community? And so we need
Facial challenge, right?
In a regard, this is a facial challenge, but it is.
So you need to show that it's unconstitutional in every circumstance.
And so one of the things that we did in the brief was we pointed out situations to show that it's not carefully tailored.
Well, I understand, but you have, I mean, this combination of cases might be just a temporal coincidence, but as a test case, you have an odd client. Right? I mean, there's argument in the briefing about the relatively low rate of recidivism, but this is not Mr. Simpson's first rodeo.
And so what I would say is that would be something to be examined at the hearing, at the second prong of the hearing where an individualized determination is made. And that's really where all of this comes back to, is that we can comply with due process if we go with the cornerstone of the Salerno case, which is an individualized determination of somebody's community risk and flight risk.
You're familiar with subsection D of the statute?
Yes.
It applies to people who commit dangerous crimes against children and to terrorists. Is it constitutional?
I would argue that I'm not asking this court to find that subsection is unconstitutional or that it doesn't go that far.
Well,
but
if A3 read the way D reads, would you be bringing this challenge?
I believe that in this context, due process requires that an individualized assessment be held. And certainly if there were an individualized assessment under D, then I would not be able to make or bring a due process analysis.
So when D requires the court to consider the effectiveness of potential release conditions, that satisfies due process in your view?
Well, I think we need to look to the Salerno case that talks about having a full-blown adversarial hearing where the burden is on the state by clear and convincing evidence to show that no other conditions of release can appropriately manage for flight risk or community safety protection.
Is that a yes?
Yes, with the full-blown hearing.
How do we read A3 in light of the existence of D?
Because D does not flush out exactly the full-blown hearing where the state has the burden for clear and convincing evidence to establish that, I would argue that the two are separate and apart from each other.
You know, you keep on using the term full-blown hearing. You know, I was a trial judge for 12 years, and I did Simpson hearings, and it's a full-blown hearing. I mean, I've had those go 3 or 4 days where witnesses come in to testify to meet that standard of proof is evident and the presumption is great. Cross-examination. But what do you mean by full-blown evidentiary hearing? You mean beyond that finding?
Yes, because whether or not those individuals pose any community protection risk or flight risk, if there is a finding of proof evident presumption great that the offense has been committed, they are categorically denied bail. And that's what really this argument is about, that the individualized determination satisfies due process because it makes the statute then carefully limited and no longer, under the punitive analysis, it's no longer excessive to its purpose.
Isn't that the argument with the exception or the case law regarding capital cases? And why does that not apply to a case like this? In other words, if the proof is evident and the presumption is great that an individual has taken young women under the age of 15 and paid them money to perform these specific sexual acts, why isn't that then implied that they are a danger to the community, and with the type of sentences that they face, they would be a flight risk as well?
With the advent of technology, with GPS monitoring, bonds, we can see in real time with that GPS monitoring where somebody is. I would argue that we can protect the community and keep somebody isolated rather than depriving them of their liberty pre-trial or pre-conviction.
Can't the same thing be said about a capital offense?
Well, again, I certainly think that similar arguments can be made in the capital offense. And I know that you don't want to hear me say that death is different. I will simply say that the punishment, there is a qualitative difference in the punishment, and I believe in American jurisprudence that
How is an individual who's 19 years old, who goes into a Circle K with a weapon, planning on robbing the cashier, who panics and shoots somebody and is charged with felony murder and is subject to the death penalty, more dangerous than someone who allegedly intentionally goes out, finds a couple of 13-year-olds and pays them money to perform obscene acts? How is that someone who's a greater danger to the community?
I think what we can look at is through an individualized hearing at the person and look at their history and the acts and determine whether or not, under an individualized assessment, that person poses a risk to the community or flight risk. I've gone greater than I would like to, and I would like to reserve the remaining portion for Mr. Cabu. Thank you.
Justin, with your leave. Counselor for the appellant, the second person on rebuttal, we're going to give him 10 minutes, the full 10 minutes that they advised. Thank you. And counsel, if you would, please.
Good morning. I'm Susan Luter on behalf of the state in both matters. To begin, in order to grant the defendant's relief, this court will have to overrule two well-established cases. Under stare decisis, this court would need to revisit both Reyes and the first Simpson and overrule your own established principles.
First Simpson didn't address this issue.
I would disagree. When reading, I realize it's your case, but when reading Simpson, you talked about the right to bail, you looked at the substantive due process as well as procedural due process, you determined that the government's interest in detaining a person may permissibly outweigh the person's fundamental rights to liberty. The interest must be legitimate.
All true. And Simpson would make a compelling justification for the constitutionality of subsection D. But Simpson never considered the question whether the denial of bail without an individualized assessment of risk to the community, flight risk, and the effectiveness of release conditions is constitutional. And to my knowledge, there isn't a single case in the federal courts of the United States or in any state court in the history of the United States that affirms such a provision. Are you aware of one?
There's also not one that says it's not appropriate.
Okay, but can we agree then that such a provision has never been upheld in the history of the United States in any state or federal court?
From my research, I would agree.
Okay. If that's the case, then what we're really talking about here is not an attempt to overrule Simpson. We're talking about a new challenge. Because if Simpson held what you say it held, you would have answered my question differently.
Well, when looking at Simpson, they did raise the issue of having an individualized hearing. Under Simpson, Basically,
Wasn't that with regard to whether the proof was evident and the presumption great?
no, I think they took it a step further. When you look at the end of at the end of the opinion, it talks about how the defendant argued not only should the court determine whether the proof is evident or the presumption great, but also whether there is compelling evidence that he is a flight risk or a risk to recidivate.
But that is a consideration that A3 expressly prohibits, doesn't
Yes.
it? Okay. So did Simpson say, because I read Simpson a number of times in preparation for today. I didn't see anywhere where Simpson said it's fine not to consider those factors.
I think it's a factor a court can consider under other release conditions. For example, under D, it would be considered, it can be for any crime if it
Well,
met
how
all
do
the
A and D?
requirements.
I agree with you, and I don't think there's any argument that D is problematic. So what we're really talking about here is, can we treat Mr. Simpson as we would treat a terrorist, or do we have to treat him more harshly than a terrorist? And so my question then becomes, can you read A3 and D together in a way that allows the individualized assessment that D contemplates?
Yes, I believe you can read them together, but let me explain why. When you look at D, it talks about the hearing, and you look at the individualized person, but it's presumed that they are a danger to the community if it's a DCAC crime or terrorist, or even under gang affiliations later on in the statute. When you go through and you look at the subsection A, basically what happens is the Arizona legislature and the voters have already done that weighing that the court would do under subsection D. What they did is they weighed the gravity and the nature of those three offenses included in subsection A under Prop 103.
But that's not an individualized assessment.
It's not an individualized assessment because they have the right under the Eighth Amendment and under the Constitution to create laws that exclude people from bail. There's nothing wrong with that.
Well, and we know for a fact under Salerno that provisions that exclude people from bail can be constitutional if there is that individualized assessment. What we don't know, what the Supreme Court did not say, is that such provisions can be constitutional without the individualized assessment. And here there is none. Right? I mean, the voters made this assessment for defendants who hadn't even been born at the time they passed this statute.
And I think where Salerno comes in is Salerno, and under due process, you first look at when there's three offenses or basically don't have an individualized hearing once the proof is evident and the presumption great that they actually committed the crime. There's what Salerno talked about. You have to do something more than just the indictment. And this court in Simpson decided to do the highest burden and have the test of proof evident and presumption great. Then, once that decision is made, the Arizona voters and the legislature said the crimes are inherently dangerous, and therefore there should be no release condition, that there is no release condition that will protect the community or a flight risk. Now,
I agree that's what happened, but unfortunately we have no case in American jurisprudence saying that can happen.
And there's no case that says it can't. And when you look at Salerno, it looks at first whether or not the reasons for having these three crimes would be punitive in nature and is it narrowly tailored. Once that is done, Salerno is done. Once they're pulled out, what Salerno, in our opinion, stands for is that once the decision is made that a crime is entitled to bail, that once a person is entitled to bail for a certain offense, then you have the full-blown hearing as discussed in Salerno to determine whether that individual is a threat to the community or a flight risk. I don't think they didn't look at our statute.
Perhaps I'm not following you, because it sounds like what you're saying is that under Salerno, if the proof isn't evident and the presumption isn't great, we go on to the individualized assessment. And that's not what the statute in Salerno provided.
Well, if the proof is evident and the presumption is not great, they are entitled to bail. At least in our case, if we find, let's say they did the Simpson hearing and they find the evidence doesn't meet the standard,
then
they're entitled to bail.
Sure. And if the evidence does meet the standard, then under the statute at issue in Salerno, the court would go on to make an assessment of each defendant's risk to the community, and if it found such a risk, could then deny bail. just like under D in our statute.
But keep in mind that when Salerno was looking at the Bail Reform Act, that's what was required. They didn't have a statute like ours, so they never looked at it.
Exactly. And so when only one other state that I've been able to find has a provision even remotely similar to Arizona's, and that's Nebraska.
Correct.
That was challenged, and the challenge succeeded. The constitutional provision failed. The case was later vacated on other grounds, so we don't have existing authority from the Eighth Circuit on it. But that's the closest I've ever seen to a review of a similar scheme, and it failed.
Well, it's hard to look at when it was basically vacated for mootness. So I don't think you can rely on that case saying that it failed.
I agree, but we can look at the court's reasoning, and we can say, even though nothing the Eighth Circuit does is binding on us anyway, we can say that the one time a court was asked to evaluate a scheme like this, the scheme failed. And never has a scheme like this been evaluated and passed constitutional muster. Now, I'm not suggesting that we keep score and because it's 1-0 that determines our result, but it is somewhat informative that we have no basis upon which to say that this novel approach to denial of bail is constitutional.
I do think we have a basis, though. I realize that the Eighth Circuit ruled differently, but we do have a basis. First of all, the Eighth Amendment is only to put a restraint on the judiciary, not the legislature, not the voters. So the Eighth Amendment doesn't apply. Here they have, and that's noted in footnote 4 of Simpson.
So if 50% of the voters in an off-year election in Arizona decided that there's going to be no more bail in Arizona, period, that would be constitutional?
That's where you have to look at is it narrowly tailored? I mean, of course, there's a slippery slope, and you could say all people, as one of the cases suggested, that are unemployed should be held without bail if they commit a crime. That's not what we're doing here. This is a very narrowly tailored statute. And if you look at under Arizona, I think it's 13706, it has the definitions of serious and violent offenses. These offenses are listed in there, and there are very few offenses out of the 570 felonies in Arizona that are class 1s through 4. We only have 3 that fall under this.
Doesn't that beg the question as to why the balance of those serious offenses don't fall under the same rubric? You pick out 3 and you say, okay, these 3?
Well, I think it's possible that you could have all the serious and violent offenses listed under 706 as it. But it still isn't so wide as, let's say, for example, Prop 100. That's a different issue, and I don't believe that Lopez Valenzuela is persuasive in this case at all.
I actually agree with you, and I don't think we need to spend much time on that. But I would ask, are you suggesting that it's narrowly tailored because Mr. Simpson is somehow a greater danger to the community than a terrorist?
Well, under
that doesn't sound narrow to me at all.
Well, it's not just. It depends on what the person's charged for terrorism for. I think that's why that crime hasn't been, like somebody shooting up at a movie theater or calling in bomb threats that aren't real can possibly be charged with terrorism. They talked about the freeway shooter being charged with terrorism, domestic terrorism. Those crimes have not been looked at by the voters and the legislature to be picked out as the other 3 were.
And if they haven't been looked at, then how can we say there was a balancing done or narrow tailoring?
The terrorism hasn't been looked at. I do believe the first 3 have been looked at by the voters and by the legislature when they enacted the referendum. Those crimes are narrowly tailored. It's not all sexual misconduct. Sexual assaults is for adults, but the age requirement has to be a class 2 felony. They are limited. It's not, for example, all DCACs don't automatically not have a hearing. They get an individualized findings because you can have DCACs for a number of offenses. So they're not just picking a group. They're picking 3 very, very narrowly tailored. And as this court said, the legislature and the voters did weigh the gravity of the offense, and it is constitutional to have those offenses be presumed based on the offense itself, as the person is non-bondable, as long as you do the hearing requirements under Simpson to show that the person is in fact the person that committed the offense.
I'm not sure I follow that argument. If you do the hearing under Simpson, to prove that the person is the person and that the offense was committed, sure, they could be non-bondable. The question is, are they properly held non-bondable under the scheme identified in A3 or the scheme identified in D? And I don't think anybody disputes that they could be held non-bondable under D if all of those showings were made. So then the next question becomes, or perhaps an earlier question becomes, you said that A3 and D could be read together. How would you do that?
In other words, if it's one of the enumerated offenses under A, and you do proof evident and presumption great in either A or D, they're automatically non-bondable under A. If it's one of the crimes enumerated under D, then they're presumed to be a threat to the community or a flight risk, and then the judge does an individualized hearing. If it's
so you wouldn't try to save the constitutionality of A by saying that we could conduct a D-style hearing even for those defendants subject to A3?
You could do that, and it would, but I don't think it needs saving. I think it is constitutional. It's just you're adding something else to the requirement under A.
Right, and if you add something else to the requirement under A because it's in D, do you think that that is a sustainable reading of the statute as a whole? Because if it were, then I don't think there'd be any argument that it's constitutional.
Well, the statute as a whole, but we're looking at A, and I understand what you're trying to say. Well, we'll just have D read into A. That's not what we're arguing for. A, in and of itself, is constitutional, and as this was brought up before, challenging a constitutionality of Prop 200, and in order to do so, they must establish that there's no set of circumstances under which Prop 103 would be valid, and the defense simply cannot do that. They cannot show that Prop 103 is not valid under any circumstance.
Because?
Because if you can come up with the hypotheticals that are out of bounds, but in this case, Simpson, as was pointed out, this is his second time here. Martinez's crimes spanned over a decade. So even if the court, if they were just charged under D and there was no subsection A, they would be non-bondable. But under A, they cannot show any case, they cannot show any other statute that says that subsection A is unconstitutional. So they have to facially challenge it. And I don't believe that they've shown.
Well, the facial challenge here gets a little bit easier, perhaps, because under A and under your reading of A, there is never a hearing that may be constitutionally required. So one doesn't have to imagine too many. One doesn't have to actually imagine any interesting factual hypotheticals, because if we never have the hearing and the hearing is required, then the statute is never constitutional.
I'm not sure I follow your line of thinking.
I mean, if you have the hearing, you could absolutely imagine that there are going to be cases where there are people who are so dangerous that they're non-bondable, and there are going to be people who are not so dangerous and are bondable. If you don't have the hearing, then you never know. And so the question is, does the Constitution require us to find out before we deny bail?
No. And when looking at it, you do have a hearing to determine the facts of the situation. You look at the defendant in the crimes that were committed to determine whether or not the proof is evident and the presumption great. You are looking at
Of the
under
guilt of
that
those crimes.
as to those crimes.
But not as to the issues that are traditionally addressed in regard to the issue of bail, right?
That's correct.
Okay,
And
so how do we get there?
The reason you get there is because the legislature made the decision that these crimes in and of themselves are inherently dangerous to the community or they're a flight risk. It could be due to the sentencing. I mean, these are mandatory flat and stacked sentences. Just because they're not looking at the death penalty, they're looking at life in prison. That is an incentive to run as well.
Well, not all defendants charged with these crimes are looking at life in prison.
But
If
they're
you've got a
looking.
single count.
You would still be facing a considerable length of time in prison.
That is true for more people than I can count in this state.
Well,
They've been charged with all sorts of offenses. That can't be the rationale.
Well, that's part of the rationale. It's not the only rationale. The crimes in and of themselves. You know, we know that these type of offenses involving children are underreported. We know that some people recommit those crimes as soon as they get out, or they just continue on for years and years before anyone ever comes forward to the police, as in one of these cases. And so you look at that, the voters have a right under the Constitution, under the Eighth Amendment, to look at what crimes they don't want people out on. It's not for punishment. It's just to protect the community and make sure the person shows up for trial. And that is permissible under the Eighth Amendment, and there is no case out there that says it's
And so
not.
what is the type, what is the finding, if you'll recall in Salerno, back up. In Salerno, Congress made specific findings about certain types of crimes that led to the conclusion that bail was less likely to be effective. What was the finding that the voters or the legislature made in this case that says, of all of the possible crimes we might charge, terrorism, dangerous crimes against children with the victim 15-year and 1 day old, all of those things, that this specific crime rises to the level that release conditions are never effective to protect the community?
Well, again, they weren't looking at that. That wasn't before them because they didn't have a law like ours. Under the Bail Reform Act, it required a hearing in every single case.
Well, but Congress looked at it when it didn't have a law. Congress looked at it in preparation for passage of the law that Salerno upheld. Did that happen in Arizona? And if so, where are the findings?
I think the legislature looked at it when I know it's through a voter referendum.
But I haven't seen any legislative findings. Have you?
Well, I don't know if they make legislative findings, but we have what was before the voters when they voted, and we know what was before the legislature and their intent when they enacted it. And I believe they actually enacted it in advance of Prop 103 passing or going into effect.
But then, so we now have two factors at issue in Salerno that we don't have here, right? We don't have legislative findings, and we don't have the individualized hearing. And this case is beginning to look a lot less like Salerno as we continue to discuss it.
Well, I think this court relied on Salerno when it found that Prop 103 was constitutional back in the original Simpson case, and also in Reyes, you did a partial analysis and found that it was constitutional and relied on Salerno as well. Salerno is different in that it didn't cover the same things. It didn't have such an act, and to say what would they have done if it had been before them. Well, this has been in law for over a decade, and you guys looked at it twice.
A lot of laws have been on the books for a long time. They may or may not be constitutional.
But Salerno came out before our law. So that wasn't before them. Their Bail Reform Act didn't encompass that there was no bail, but they never said that they couldn't.
And Arizona passed a law. Don't worry about your time. We can give you a little more time. Arizona passed a law after Salerno that mirrored Salerno and that everyone agrees is constitutional. And that law is subsection D. Why didn't it do the same thing with subsection A?
Because subsection D has been around longer, is my understanding. Now, I don't recall when terrorism and DCAC was added. It was separated out initially, and then violent crime was kind of added in, and now it's been merged into one subsection. So it's harder to read when you read it. But I believe that under Salerno, first of all, they did say that the government's interest in preventing crime by arrestees is both legitimate and compelling. So I don't believe that they would have ruled against us had this particular statute been before them. I think they would have found it constitutional. We believe it is constitutional. Then when looking at that, they didn't do that because the voters, and some of it is on the pamphlet information that was presented to this court, is that they felt the bonds were too low, that the judiciary was not handing out bonds that were sufficient to make sure that these offenders returned for their trial or that they were repeat offenders. So then the voters took that under consideration and have the right and the ability to exempt certain crimes from bail, and that's what they did here. And there is no specific finding that this individualized person has to be looked at.
Go ahead.
Counsel, we have this large body of law out there in numerous states that says capital cases categorically can be non-bailable. And it doesn't violate the Eighth Amendment. It doesn't violate the Due Process Clause of the 14th Amendment. If the underlying presumptions of that is there's something inherent about someone being charged with a capital offense, that they're a danger to the community and they're a flight risk. Why don't those same principles apply to these offenses?
They do. The only difference which petitioner would say is because it involves death. But not everyone who is a death capital case pending against them receives a death penalty. So that's one thing. It doesn't automatically mean. I realize that there's some authority out there that talk about that they will do anything to avoid the death sentence, even if it means losing money on their bail. But that's the same rationale can be applied here.
Okay. Let me express my concern on the other end, because I'm concerned there's an inconsistency. If this provision is held unconstitutional, then I don't know as a principled matter why capital cases should be non-bailable either.
I agree with you.
But here's the flip side of it, and Judge Swan somewhat alluded to it in his questions. Where does the will of the voters end in terms of adding offenses to this list of non-bailable offenses? If the voters can conclude that certain offenses have this danger to the community and flight risk, that could apply to just about any offense. I mean, if you look at somebody who's been the victim of a home burglary, that's a very dangerous situation, that someone enters into a person's home, especially if they're there. That person never feels safe in their home ever again. I mean, I've heard those victims testify in court. There's some evidence, and I guess this is going outside the pale of our record, but I think that there is some evidence that perhaps those who engage in home burglaries do so, at least some portion of that population, on a regular basis. In other words, why wouldn't we add burglary in the second degree? Why wouldn't we add aggravated assault with a deadly weapon or serious physical injury? And I don't know. I mean, at some point, do you see the possibility of adding these presumptively non-bailable crimes sort of swallowing the 8th Amendment or the 14th Amendment?
I think it could happen at some point if you have too many crimes. But Salerno addressed that. You have to look at the individual offenses that are added. And in that, it narrowly focuses on a particular acute problem in which the government interests are overwhelming. It operates only on individuals who have been arrested for a specific category of extremely serious offenses. And I think that's where Salerno draws at least part of the line. And that's what we have here with these three types of offenses.
Is our scrutiny limited to whether that's been done prior to the passage of A3? Or
I believe that has to be narrowly tailored. I think that's required under the Due Process Clause.
You pointed out, though, that there are hundreds of crimes in Arizona that qualify as extremely serious felonies.
Not hundreds. Under Prop 100, their definition of serious was different. And I'm not going to go in there.
I think you said there were 500 and some.
That was for just class 1s through 4.
Okay.
That's under the serious under that.
Is there anybody who would say that any crime that is a class 1, 2, 3, or 4 felony is petty? I mean, they're all serious. Right? The home invasion is a very, very serious crime. Terrorism is a very serious matter. At what point, you said that it could become a problem if there are too many. How many do we get?
Well, I think under 706, which are those crimes are listed, first-degree burglary, which is a home invasion usually, terrorism, the 3 crimes that are listed. 706 includes serious and violent offenses. There's 24 violent offenses. And I believe there's 12 serious offenses, 8 of which are subsumed in violent. Those crimes, that might be the limit. What does the legislature deem as serious or violent under 13706? That could be deemed the limit. And maybe not all of those would qualify as absolute non-bondable if we prove the person committed the crime under the Simpson standard.
So the question is the number of crimes that are under this statute as opposed to the structure and administration of the statute?
No, not the number, but I think at some point there are a lot of violent crimes. But looking at the number that I had said earlier, 570, somebody might say at first blush there's a problem. But 3, you look at the percentage, on its face it's not a problem due to the number. Then you look at the individual crimes that are listed, and these individual crimes pass constitutional muster. If there's concern about a slippery slope that we add, since we have capital, that opens the door for the other offenses, and capital is presumed to be okay. And I agree that if for someone says you can't have any other crime but capital, then there better be a good reason why capital is the only one that qualifies. And I believe that capital does qualify, and that there are certain offenses that are narrowly tailored that will pass constitutional muster, and these 3 offenses are included in that.
So we could really be unique in the nation then. Only 2 states have one crime other than a capital crime that qualifies. But you're saying we could have a couple dozen.
That's not before you today, and if you're concerned how far does the door go, those would be analyzed as the time comes. I mean, that's why the courts are here. If for some reason the legislature just starts adding crime after crime after crime, then you need to look at why are they doing it? Is it narrowly tailored for a legitimate government purpose?
You need to look at that the first time
Yes,
you do it.
and that was my question. Is it the number of crimes that we're applying it to, or is it as to the first crime we apply it to, whether or not it passes constitutional muster?
The first crime you would look at. I think you would look at each crime. Under this statute, though, they're claiming it's facially invalid. So if you find that one passes constitutional muster, it all passes.
Thank you.
Thank you.
Thank you.
Your Honors, my name is Jean-Jacques Cabou. I represent Petitioner Martinez. I want to start with first principles and try to reframe the doctrinal discussion. It seems that both we and the respondents agree that the question is not whether there's a compelling state interest. There is. We've conceded that. The question is whether the no bail restriction in Arizona's Constitution, as implemented by Arizona statutes, is narrowly tailored to serve that interest. That's the doctrinal framework that we're all operating under. And the Supreme Court in Salerno told us how to judge whether or not something is narrowly tailored in the specific context of a restriction on pretrial bail. They told us to apply a 3-part test.
They didn't exactly tell us to apply a 3-part test, did they? They applied a 3-part test because they had a 3-part statute.
That's correct, Your Honor. But no court has ever, as this court acknowledged in its Simpson ruling, which we agree has something to do with this case but does not control the outcome in this case. As this court acknowledged in Simpson, subsequent decisions of the Supreme Court and other courts that have dealt with the procedural due process requirements of curtailing the right to bail have all considered the factors in Salerno, none greater than the right to a, quote, full-blown adversarial hearing that asks the constitutionally correct question. And that question is a question posed here but not posed in Salerno. To address Judge Gould's question from earlier, we certainly do not dispute that the hearings under Simpson that are held are full-blown. There's a right to counsel. There's a right to cross-examine witnesses. There are all the indicia of the adversarial hearing that's at the basis of our constitutional system. What it doesn't do is allow inquiry into the proper question. And that question is not, is the defendant probably guilty, which is admittedly a colloquial way to describe the standard, but that's what it's about. It's a rump inquiry, a lesser inquiry into guilt. But the Constitution requires a different inquiry at this limited stage. At this stage, the Constitution we have to inquire into whether that person is dangerous, such that no other condition but detention can guarantee the safety of the community, or whether that person is a flight risk, again, such that no other condition is necessary.
Do I have to do that, counsel, in a capital case?
You do not, Your Honor.
Why?
Because,
that is different.
No.
I'm going to come down off this bench and I'm going to strangle you.
And Your Honor, foreseeing that, I'm not going to say that. What I will say is that the punishment of death is irrevocable. It's like no other.
Yeah, but we're talking about bail. We're talking about bail. We're not talking about sentencing. I'm talking about bail, being held pre-trial. Why is it different?
Your Honor, the Supreme Court has instructed that where there is a categorical prescription on bail, that prescription has to have inherent within it a, quote, convincing proxy for flight risk or dangerousness. And where someone is charged with a capital offense, we do not contest that that is a convincing proxy for flight risk.
Why doesn't that apply to sexual conduct with a minor under age of 15?
Well, Your Honor, the reason it doesn't apply to sexual conduct with a minor under age of 15 is because someone risks a term of years in prison, and those may be long. But that is no different from many other crimes.
So you're arguing it's not different than any other crime? Counsel, many crimes are not prison mandatory. Many don't involve victims, and many don't involve children under the age of 15.
Your Honor, I agree that the crime charged is serious.
That's not different?
The seriousness of the alleged offense is undoubtedly among the most serious offenses. What it isn't is a risk of irrevocable punishment. What it isn't is a mandatory life sentence, which one state reviewing a no bail provision that applied to mandatory life sentences did apply the Salerno framework.
Was that state correct? Because I understood what you were saying to be that the punishment in a capital case is death, and so when you hold someone non-bondable before trial, you're not inflicting the punishment because you haven't killed them. If the punishment is confinement and you're holding them before trial, then the punishment is being inflicted before trial. Is that the basic theory?
I think that's part of the theory, Judge Swan. The other part is that given the risk of death, which is ultimately final and can't be changed, can't be challenged on appeal, that's the legal system, soup to nuts, treats death.
What do you mean it can't be challenged on appeal? What are you talking about?
Once you're dead, you can't appeal.
Oh, okay.
Agreed. But the legal system, starting from the very beginning of a death case, does have differential procedures for those matters. You have a right to learned counsel. In certain cases, there are higher standards for counsel. There are higher standards for appeal. There's automatic appeal in our state to the Supreme Court in the first instance. So the judicial system, top to bottom, treats those charged crimes differentially. Now, whether it's correct to apply to a mandatory sentence of life in prison, we would argue that it's not, but that's not a fight we have to win in order to win the facial challenge, and we agree it's a facial challenge to the statute. Now, the reason that it's a facial challenge isn't because there aren't some cases where the state might have a very good argument that a particular defendant shouldn't be detained. Undoubtedly, there will be those cases. There might even be a great number of them.
I can well imagine that they might have some pretty good arguments with respect to Mr. Simpson.
That may very well be, Your Honor, but it may not be. And that possibility that may not be is what requires the court's holding that this statute is unconstitutional, and so is the constitutional provision that required it. Liberty is the norm. Where liberty is constrained categorically, it can only be done in a way that comports with procedural due process, right? The substantive right is liberty, and the procedure that implements it has to be right. And Salerno told us about those
And it's
procedures.
no longer categorical, right?
Well,
if you're making an individualized assessment, then you're not categorically depriving a class of people of liberty. Are you saying that any categorical deprivation is unconstitutional?
We're saying that the categorical deprivation here that applies to non-capital defendants and that precludes a court's inquiry, even where the court would want to inquire, but the court is affirmatively precluded from considering that in all cases. And because that inquiry, in the absence of legislation and legislative findings that demonstrate a convincing proxy for flight risk or dangerousness, in the absence of that, the Constitution requires an individualized inquiry. It may very well be that there are cases where that inquiry results in a finding that that person should be detained, and that those are the least restrictive conditions necessary to guarantee their appearance and necessary to safeguard the community. But if the legislature, and there's no finding in this case, has not put forward a record and cannot, and the enactment cannot be substantiated with a convincing proxy, then an individualized determination is required. The individualized determination under Section D, we agree. If that were allowed, right, it calls for clear and convincing evidence, it calls for a sworn proof, it calls for an adversarial hearing. That's all we're asking for. And I want to get back to the relief we're seeking. This is an important principle of law. It may have sweeping implications if we're correct. But the relief is modest. The relief we seek is a hearing about whether or not the individual defendant who stands to be otherwise deprived of his or her liberty just based on an indictment, an ex parte proceeding, has a right to demonstrate that they're not
Well, we know that under either A, 3, or D, the ex parte proceeding is not determinative, right? There's at a minimum the existing Simpson hearing.
Yes.
Okay. Do you agree that subsection D is constitutional?
I agree that subsection D is constitutional so long as there's my only caveat on that is it's not clear from subsection D that it allows an inquiry into flight risk and dangerousness. My reading is that it just talks about dangerousness. And
Dangerousness is enough, right? If a person poses a significant enough danger to the community, Salerno says
Yes.
that we can make them non-bondable.
and we agree with that, Your Honor.
Okay. So D is fine.
Agreed.
Is there any construction that you can come up with that allows a D-type hearing in an A-type case?
I would say that I wish there was, Your Honor, because that would make all of our collective tasks substantially easier. But I am not, I have to read A as being mandatory because it uses mandatory language and the history of the proposition uses mandatory language, and it says that a person who is in custody shall not be admitted to bail. I view that prescription as mandatory and therefore fundamentally inconsistent with D and with the Constitution.
Counsel, doesn't it begin by saying except as provided in subsection A of this section?
You're referring now to D?
D.
It does, Your Honor.
So it seems to accept itself from the considerations of A.
Well, I guess, Your Honor, I was viewing the problem from the other end of the telescope, perhaps, which was I'm looking at A and saying, is there any way around the mandatory prescription on a hearing?
You are probably right. We are probably looking at it from the opposite ends. But doesn't D, in fact, say that D doesn't impact A?
Your Honor, honestly, I've never read it that way, but certainly that would that statutory construction would afford us the relief we seek, which is an individualized determination as to flight risk and dangerousness.
Thank you.
I'm just curious. This situation came up over the years, and I want to get your input on how it applies here. Under ARS 133968B, if a person is on release and they commit a new felony while on release, if there is probable cause they committed the new felony, the court can revoke their probation. They can be held without bond. So the finding there is solely, is there probable cause they committed a new felony? And based on that, you can hold them without bond. It has nothing to do with an individualized finding of dangerousness, any of those things. It's just probable cause they committed a new offense. Is that constitutional?
Your Honor, I read that statute as permissive. It says the court may revoke release, and we wouldn't presume to say that in all cases the court shouldn't be able to do that.
So it's the irrebuttable presumption.
Yes,
Based on the category.
Yes, excuse me, I'm sorry. The irrebuttable presumptions in general are wholly disfavored by law for good reason, because there may be a case where a trial judge may want to consider that evidence. And because the law as it's enacted now, as the voters voted for it, is wholly inflexible. It requires that no judge inquire into the issue of flight risk and dangerousness, an inquiry required by the Constitution in all but a very limited scope of cases. That is the facial problem with the statute. I see that my time has expired, and I want to respect the extra time the court gave us, so unless there are further questions, I'm inclined to sit.
Counsel, thank you.
Thank you.
I think by the extension of time, I hope by the extension of time that you would understand that we really did want to hear what you had to say. We appreciate your time, clearly your investment in the case itself. We will, at this time, take the matter under advisement, and we will issue our decision in due course. Thank you.
Thank you, Your Honors.